morning, everyone. My name's Llona Millar, and I will be chairing this morning's session on litigating climate change displacement, cutting-edge cases and decisions. Before we begin today's session, I would like to acknowledge the traditional owners of the land on which we are meeting virtually today, and pay my respects to their elders past, present and emerging. Today, we have a very exciting panel to talk about one of the most pressing and urgent issues in respect of climate change, being the matter of climate change displacement. People fleeing disasters and the impacts of climate change are often entering an unmapped legal landscape and faced with the challenges of not only legal gaps in the systems to protect those people, but also overlapping areas of issues and jurisdictions. So what we see across the world today are courts and other tribunals considering how laws may be shaped and developed to address these unprecedented circumstances driven by both natural disasters, but also slow onset events as a result of climate change. We're seeing different approaches in different jurisdictions. And as a result of these challenges, we're seeing in some cases some quite creative solutions being proposed to address these issues and protect the people that are affected. In recent years, we've seen a large number of climate change cases being brought in jurisdictions around the world, and these are relying in many cases on causes of action linked to human rights obligations being owed by states to their citizens, and also cases that look at the establishment of duties of care owed by states, decision makers, and indeed recently we've seen cases where duties of care have been held to apply with respect to companies as well. So today we will be hearing perspectives on these matters from four highly distinguished experts. Today we have with us Robin Bronen, who has been working as a human rights attorney and social scientist on climate forced displacement for Alaskan Native communities for many, many years. Robin co-founded and directs the Alaska Institute for Justice, which is an institute that is focused on the protection of human rights of the Alaskan people, advocating for immigrant rights and climate justice. We also have Amma Francis, who is a climate displacement project strategist at the International Refugee Assistance Project, or IRAP, and she has been developing the organisation's strategy in collaboration with the Natural Resource Defence Council and looking at how you expand legal protections for climate displaced persons. Amma is also a non-resident fellow at the Sabine Centre for Climate Law at Columbia University, and has been very actively engaged in developing legal solutions on climate displacement. We also have with us today Solomon Yeo. Solomon is a climate activist from the Solomon Islands and has been leading as campaign director the Pacific Island Students Fighting Climate Change. Solomon's one of the 26 law students who founded that organisation and serves as the campaign director, and the Pacific Island Students for Fighting Climate Change are currently campaigning for a UN General Assembly resolution seeking an advisory opinion from the International Court of Justice on climate change and human rights. And our fourth speaker today is Adam McBeth. Adam is a barrister who practices at the Victorian Bar, primarily in public law, including judicial review, constitutional law, immigration and human rights. Adam also has a strong academic history as the Associate Professor at Monash University's Law Faculty, and as a Deputy Director of the Kaldor Centre on Human Rights Law. He's written extensively on public international law and human rights, and will be speaking today about an action that he is involved in on behalf of Torres Strait Islanders facing climate displacement. So we have a great lineup of speakers coming from very different global perspectives. And without further ado, I'll move into the format of today's session. We have about 35 to 40 minutes of Q&A with the panel, and then there will be an opportunity for audience questions. And I would invite people to submit their questions through the chat function or the Q&A function. And we will try and integrate those questions throughout the discussion this morning, and also have time for questions at the end. So, Robin, if I can ask you to come online, and we'll get started. You've been working on issues related to climate-related displacement of Alaska's Native communities since 2007. Can you tell us a little bit about the work of the Alaska Institute for Justice and the policy and advocacy that it's been undertaking?
Yes, and thanks so much for the introduction. So first, I just want to talk about polar amplification to understand the crisis that we are in globally. So for those of you who don't know, the Arctic has been traditionally warming since 2007, twice as fast as the lower latitudes. And right now we're 3 times as fast as the lower latitudes, which means that we have far surpassed the 2 degrees Celsius benchmark that the Paris Agreement tried to meet. And we've been warming 3 degrees Celsius in the middle of wintertime when the sun barely rises above the horizon. And that has been catastrophic for Alaska Native communities, especially those that are located along the coastlines of Alaska, because Arctic sea ice, which is the ice that covers the Arctic Ocean, it used to be 9 months out of the year. Arctic sea ice is rapidly disappearing from the planet. Arctic sea ice is also the air conditioning unit for our planet. And without that, communities don't have the natural barrier that protects their communities from the fall storms that we get. And it's causing accelerated rates of erosion and thawing permafrost. And as a result of that, communities are having to make the awful decision about whether or not they can remain where they are. One community, Newtok, has been trying to relocate for over 20 years. Federal and state government agencies decided back in 2007 that they had to relocate by 2012. It is now a decade later. 1/3 of the community is safe and 2/3 of the community are living in a humanitarian crisis. And there's no timeline for when they will be able to move to their relocation site.
Gosh, that's harrowing to hear about those impacts on the ground in such circumstances. I mean, as you've been working on these issues, how have you seen the recognition of climate-related displacement change over the years? Are you starting to see more traction coming from governments, regulators, and other institutions? And also, are you seeing sort of a greater acceptance and recognition of the science and impacts?
What I'm seeing are more academics and researchers involved in the issue, and I continue to see an incredible reluctance. And I most know, of course, the United States government and the extraordinary reluctance for the United States government to step into this space of creating a governance framework that can help facilitate the availability of resources and technical assistance so that Alaska Native communities get what they need if they make the decision to relocate.
Yeah. So in these circumstances, litigation is one of the tools that we have to try and sort of advocate for change and to highlight the issues. North American Indigenous communities have brought some of the leading cases, raising the impacts of climate change and how those impacts will affect their fundamental human rights. Do you see these cases as playing an important role? And can you talk a little bit about any of the litigation that your office has been involved in?
So I think the litigation is critically important, especially now more than ever, because the tools that I have used, for instance, the advocacy tools, have not been sufficient in order to get the US government to act. And the Alaska Institute for Justice filed on behalf of 5 Indigenous communities, 1 in Alaska, 4 in Louisiana, a complaint with the UN Special Rapporteurs, 10 of them, seeking to hold the United States government accountable for the human rights violations that are being caused by the climate crisis and the US government's failure to act. And we are now asking the Biden administration to officially invite the UN Special Rapporteur on the human rights of the internally displaced to the United States so that she can document and investigate the human rights violations that are occurring in Louisiana and Alaska.
Gosh, so, you know, litigation is one tool, but a lot of the work that that the Institute is doing is focusing on looking at how to sort of make more effective the community-based relocation programs. Can you tell us a little bit about the research projects that you've been undertaking in that space?
Yeah, so that's the critical part of the work that we're doing. The litigation is a tool that needs to be used, but what we need is a model. And what I call a governance model of what a human rights-based relocation governance framework looks like, because throughout the world, we have horrific legacies of government-mandated relocations where the government makes the decision that a community needs to relocate, chooses the relocation site, and people suffer horrifically as a consequence of that. So we're working with 15 Alaska Native communities. They are leading our work and designing a governance framework that protects their right to self-determination, their tribal sovereignty, that will ensure that they will be able to survive and thrive as the climate crisis continues to permanently submerge the land where their communities are located.
So very much community driven and sort of determined by communities rather than by institutions and external forces.
Yes, they decide the questions we ask. You know, when we are seeking research dollars, they guide us when we are using advocacy strategies to engage with government agencies such as the Federal Emergency Management Agency, which is the government agency in the United States that has the responsibility to respond to disasters, and housing and urban development. So they guide our comments to ensure that equity and justice and human rights are foundational, because in the United States, US government agencies have still are harboring the colonialism and racism upon which these institutions and governance mechanisms were founded, and they need to be removed in order for communities to get access to the resources they need.
Yeah, indeed. No, thank you. Thank you for that, Robin. I'll bring in Arma Francis now. Arma, you've been working on the International Refugee Assistance Project. Are you able to tell us a little bit more about that and how that sort of provides another sort of framing for displacement in North America?
Sure. So the International Refugee Assistance Project, IRAP, is an organization that organizes law students and lawyers to enforce the rights of refugees and also displaced people. And we approach this work through 3 main lenses. We provide direct legal services to clients, but also strategically litigate and engage in advocacy on behalf of clients. And something that's unique about IRAP is that the advocacy work and the litigation work that we do is really informed by the needs that are coming up with the client work that we do. We recently launched our climate program earlier this year, and it's really exciting for us to be doing this work.
Yeah, so in terms of the climate project and the sort of program, could you tell us a little bit about what's involved in that that program And perhaps even before that, what is the current status of protection of refugees that are being displaced by climate change and coming into, in your case, the United States?
Sure. I think it was pretty clear from Robin's remarks the urgency of this issue. I've heard it be described as this decade as the one that's most critical in terms of climate action. And I think that's true. Something that we're seeing is that climate is already emerging as a lead driver of displacement. So climate related and other environmental disasters are displacing 3 times the number of people within their own countries than conflict. And while that's their case, the law just isn't where it needs to be. There are no multilateral treaties that comprehensively address climate displacement, nor are there domestic frameworks in place that really comprehensively make sure that people's rights are protected and that they can move in safety and dignity. I think like at just top line, it's really important to highlight that the majority of people who are on the move in the context of climate change are Black, Indigenous, and people of color. And that's true whether people are moving within their own borders or are making the difficult decision to move as communities within their own countries, or whether they're seeking safety across borders. And for us at IRAP, that means that it's really important to center justice as part of this work. Yeah, if you want to jump in, you seemed like you wanted to jump in with a question.
No, so I was going to ask. So with that justice focus, I mean, what are the types of changes that you're seeking to implement, or are there particular forms of legal instruments that you see as being the model to assist people in achieving climate justice in the context of displacement?
Sure. Here in the US, the Biden administration just ordered a report on climate's impact on migration. And in response to that interagency governmental response report, IRAP released our own report with a set of recommendations for the Biden administration. And the key takeaway from that report is that there are existing legal tools that the US government at very least can be using. And I'd be happy to talk more about those. But I think the really important point is that if migration is going to be a viable adaptation strategy, it's really important that we have the legal frameworks in place to support that movement.
Yeah, so perhaps then can you outline a little bit more about those legal strategies and what you see would be sort of best practice, or leading the way to facilitate that orderly approach?
Yeah, I think before I answer that, it's also important to note that the majority of climate displacement happens within borders, but some people are forced to seek shelter in other countries. And I think what's less talked about is the fact that, as I said, the majority of people experiencing climate displacement are Black, Indigenous, and people of color. And when we're talking about being able to migrate from the global South to the global North, it takes an incredible amount of resources. And so the work that IRAP is doing is focused on cross-border displacement, and again, centering this idea of global justice, where migration is part of a just response to the climate solution. And so within that frame, one of the key issues that's been longstanding in this area, and in part due to the work of the Kaldor Centre, is whether or not people moving in the context of climate change qualify as refugees. And in recent times, the UN High Commissioner for Refugees, UNHCR, issued guidance that says that climate displaced people can qualify as refugees. And part of the work that IRAP is doing in partnership with other organizations is to highlight successful cases here in the US where people had a climate-related element to their asylum claim, and to also represent climate displaced people in hopefully successful asylum claims.
Great. Could you perhaps tell us a little bit more around those examples of the asylum cases? How have they been sort of how have they played out, and how receptive have courts and tribunals been to those arguments?
Sure. So The way that climate shows up in a lot of the cases that we've highlighted so far is that it heightens persecution, but it's not necessarily the central element or grounds for people getting relief. So one story that's in our recent report, for example, is of Isabel, who's an Indigenous Honduran woman who was fighting government appropriation of her tribal lands. The lands were climate vulnerable. Isabel stood up and was able to gain asylum last year in the US based on her status as an environmental defender. And in that case, climate was contributing to the dwindling resources that Isabel's tribe had access to, and also created pressure or created more of a context for the government to have incentive to try to seize those lands. And so part of the work that we're doing, though, is to also push the law a little bit within existing frameworks to say, if governments are, for example, investing in extractive industries and communities against their wills, and those communities are then facing crop failure, starvation, it's really important that the law be able to recognize that as harm that's worthy of relief.
Gosh, that's really, quite fascinating. I hadn't sort of thought about that angle before in terms of the persecution for environmental activism, because we have seen that sort of throughout the world. Very strong examples of that persecution of people standing up for environmental justice. It's fantastic to actually see that, obviously not in a positive way, that is still happening, but that there is a recognition that is connected to those concepts of persecution, and that asylum can be sought on those grounds. I might now bring in Solomon from a Pacific perspective. So thank you very, very much, Alma. And I think we'll come back to hopefully some of these issues in the Q&A. Solomon, can you tell us a little bit about the work that the Pacific Island students fighting climate change have been doing? What was the motivation behind setting up the organisation and bringing your campaign to the General Assembly?
Thank you so much, llona, and colleagues, for that great presentation. It was really interesting to hear this different perspective together again. Yes, and for your question, I think the motivations behind the organization's formation really is, of course, many of the students who are taking part of this are all Pacific Islanders. We are as one person claimed it, living experts to the climate crisis. We have grown and molded by environment, but now we are seeing that the environment is somehow turning against us as well, and causing many of complications and discomfort to our fully exercising and enjoyment of even our basic human rights. So the adverse impacts of climate change is really real, and that is, I guess, the foundation for the motivation. But building onto that, we're also seeing that the progress in terms of the climate change regime internationally, regionally, has been moving at a glacial progress in terms of addressing the issues that we are facing on the ground. We also identified that there's many gaps in international law that needs to be addressed in terms of assisting or complementing the international progress on addressing climate change as well. And for the sake of this topic, we also noticed that despite internal displacement, preparation in the region, the Pacific region, is beginning to take place. Frameworks for external migration, although a very last resort for Pacific countries, it still remains underdeveloped, with several gaps in international law and politics that makes climate migration possibilities a bit difficult internationally. Yeah.
Yeah, Solomon, I was going to say, I mean, one of my experience working in the Pacific has been, there's a sense that, displacement is a potential consequence of the climate change impacts, but for many years there was a reluctance to talk about relocation and management of that, on the basis that what was front and center was the need for very urgent and ambitious action on climate change. Do you find that, there's still very much a need for that urgent action on climate change? We have to try limit warming to 1.5 degrees in order to protect our communities. But do you see now that the discourse around displacement in the Pacific and the need to have an orderly approach to relocation is now seen as a viable sort of approach with respect to adaptation, like Amma was mentioning?
Yes and no, because at the moment, the conversation on climate displacement has been mostly been situated. Although I'm not too confident in speaking for other Pacific countries, but I speak for my country, Solomon Islands, where I'm from, and I'm based at. Our country, the discussion on climate displacement has all been centralized in the urban areas, where the governments are, where the developing partners are, where the key civil society are. But that is just a minority of the minority of the population. The majority of the population lives in the rural areas. So these people, although seemingly understand what climate change is, but that the complex issue of climate displacement or climate mobility, that might be quite of a new topic to them as well. And it requires a lot of awareness raising and a lot of discussions that needs to be made. So I would say in terms of prioritizing this issue at the moment, in terms of community level and to the national level, we're still trying to calibrate towards that.
Okay, thank you for that. Now let's talk about the work that you're doing, seeking an advisory opinion from the UN General Assembly to seek an advisory opinion from the International Court of Justice on climate and human rights issues. Can you explain the key sort of questions that you would be looking to frame that opinion to address?
Yeah, thank you for that question. Yes, so when the organization formed, the 27 law students got together, we decided to delve into so many research points on how can we use the law to drive climate action. So we done some couple of research, and then we come across the International Court of Justice advisory opinion, which is not new concept to the Pacific, which was taken before by the Palau government in 2011 or 12 in their campaign for the advisory opinion. Now, the question that they were pushing for back then was really towards state responsibility. And having thought about that, the students have thought that maybe a better could improve on that question. So the framing that we're looking to see is that although ultimately the negotiation needs to be done by the state, the diplomatic negotiation on actual legal question that we put forward to the UNGA and then to the court, the youth campaign has developed a question on framing under what are the obligations of states under international law to protect the rights of the current and future generation from the adverse effects of climate change. The two central themes, the legal question here is focusing on state obligation towards human rights and intergenerational equity.
Great. I think we certainly are seeing globally a number of the climate change cases that are being brought by children and children's representatives on the basis of the impacts of climate change on future generations. Can you tell us a bit about the level of support that you're getting in terms of and the process that you need to go through to enable this matter to progress to the ICJ?
Absolutely, but it also would like to highlight that campaigning in the Pacific, especially climate, in this very complex issue of using the law, it can be really difficult. We have, as young youth campaigning, it's really difficult in terms of trying to influence the process, get partners, building the momentum. It has truly been a challenge, but we have pushed on forward to, fortunately, to reach this far in the campaign. The progress, although it's been a slow start in the beginning, it has just, the momentum just escalated most recently. And we have continued to raise awareness with government officials, attorney generals, offices around the region on the matter. The response was very positive as well. You're getting a lot of support from a lot of civil society, other governments, and also key stakeholders to the campaign. Vanuatu government has just recently announced that they are concretely taking this campaign towards the UNGA and will be conducting diplomatic negotiations with the state. The process on getting this advisory opinion central to this at the moment that we're heading towards is to build a simple majority vote at the UNGA once it's being tabled. So the focus right now is building that bandwagon of coalition of states who will be able to vote yes at the UNGA. So all we need is a simple majority vote at the UNGA. And going forward, we see the next step for the campaign is towards COP26 at Glasgow, and we're planning to implement a month-long campaign plans to build on the momentum on this, so that we can get more states to support or are aware of this campaign and hopefully vote yes at the UNGA.
Yeah, no, look, I can imagine it's a very sort of involved program of diplomacy to try and sort of really win over, and explain to governments around the world the importance of this issue and the need to get these questions answered by the International Court, and to set those advisory opinions. I mean, one of the things that I think we've seen, there have been other sort of campaigns and approaches in the past seeking advisory opinions from the ICJ and trying to sort of garner that political and governmental support. But you've mentioned that one of the distinguishing features about your case now is that it's being brought on behalf of young people and in respect of the impacts of the rights of children, but also future generations and the intergenerational equity principle. But do you also see the potential for movement here being supported and enhanced by the changing attitudes to the scientific evidence around climate change, and in particular the attribution component? Because I think certainly what I've seen in a number of the other sort of climate cases brought globally is we're no longer arguing about the science. We're no longer sort of seeing states or even companies challenging that climate change exists, is real, and is having the impact it's having. Do you think reports like the IPCC's sixth report and the body of scientific evidence around climate impacts is something that will support your ability to bring this action?
Yes, I think you raise a very important question, and of course that question is also very, I guess, the stumbling blocks of many, the attribution scientists, stumbling blocks of many climate litigation cases that we brought before the court, which is really difficult to establish that. And I'm still hearing a lot of experts speaking with them that saying that it's really hard, it's still yet hard, regardless of the science, to establish the climate attribution to a particular state or corporation or entity that is perpetuating this degradation of our climatic systems. I can only speak for the fact that this campaign is not, you can classify it as climate litigation, but it's more just seeking a process or a performance by the court in just giving in its advisory opinion. But it is through this advisory opinion that we see that it can entertain a wide variety of climate science, and also the facts and the essential international, and giving a whole robust understanding of where things are and how can particular areas or gaps can be further clarified. Regarding the IPCC report, it brings new perspective indeed to the recent one. It brings new perspective to addressing climate change. It really highlights now that it is human beings are the primary drivers of the dangerous level of climatic interference. For regards to the campaign, it continues to reinforce the existential threat climate change is really posing to our survival in the Pacific. But however, it also strengthens our case in terms of our credibility, and continues to remind, especially young people engaging in the campaign, why are we in this campaign in the first place, and the dire complications of why we are not choosing, if we choose not to act.
Yeah, no, indeed. And I've just had a couple of questions coming through the Q&A. One of the questions is around, we're talking about international courts and tribunals and as a forum to address some of these climate change sort of matters. But are you also exploring opportunities within the domestic courts and anything else within the Pacific and the Solomon Islands in your case particular?
With relating to if I may ask.
Whether there are any domestic actions being brought with respect to climate change impacts. Is anyone sort of, for example, looking to hold local governments to account? I mean, I can imagine it's difficult in the Pacific because the Pacific governments have indeed been the ones that have been at the forefront advocating for climate action. But you know, certainly in Australia, and we'll bring Adam in just a minute to talk about how we're looking to hold developed country governments to account. But since the question came through, I just thought I'd ask if there's anything sort of domestically happening in the Pacific.
Yes, that's a very interesting question indeed. The short answer is no, but with regards to that, in terms of how there might be a avenue that this might be more common in the future even for the Pacific, because there's a political will going on around Pacific states on trying to develop frameworks and legislation. You can see the recent climate change bill that has been endorsed by the Fijian Parliament that has that opportunity or allows for the individuals or stakeholders in the country to sue their governments for their failure to uphold their targets or failure to perform the act accordingly. So there's an opportunity to do that in the future, I guess so. But then for the other Pacific Island countries, still we do not. Many of them still do not have a climate change act. We also, but yet we still are developing other frameworks that also the failure of performance of those frameworks, especially climate for the Solomon Islands, you have the climate relocation guidelines that we're developing that failure to performance that you can potentially have potential cases in domestic courts.
Okay, great. Well, I think with that, I will bring Adam in. Now, Adam, you have some slides which I will hopefully have shared. I'm hoping that people can see the slides from Adam. Is that correct?
Yeah.
Yep. Okay.
I can see it. Yes.
You can see it. Okay. If you can see it, then I think we're great. So, Adam, you know, in Australia we have Indigenous communities who are also facing, you know, extreme climate change risks, including the risk of displacement. Can you talk a little bit about how these risks are playing out and what, you know, how the community is addressing these risks, and perhaps, you know, tell us how, you know, what role does climate litigation sort of play in the approach to addressing these risks?
Yeah, thanks, Ilona. I can talk to it in relation to these 8 individuals you can see on the screen there. I'm not sure about that I can speak for Indigenous communities more broadly, but so the case that I'm involved in, sometimes colloquially called the Torres Strait 8, the formal name is Billy and Australia, a case to the United Nations Human Rights Committee for breaches of the ICCPR by Australia. If you flick through the slides, Elena, you can see the inundation of the island. So it's brought by 8 individuals who live on 4 different islands in the Torres Strait, and the complaint is basically about the inundation of their islands by seawater caused by climate change, and the evidence and the statements from these individuals and from their communities is quite striking when they talk about how things were in their memories, within their lifetimes until how they are now in terms of the encroachment of the sea. And so some of the impact you can see in that slide in particular the complete erosion of the land itself and the creeping up of the shoreline, but you also get inundation of the seawater over their subsistence gardens. You can see that slide on the right, the text sort of covers it a bit, but you can see the wheelie bin there underwater, among other things. So there's a direct threat to their housing. There's a direct the subsistence gardens where they grow their vegetables and their fruits are no longer able to grow anything because of the inundation of the seawater. The graveyards where their ancestors are buried are being, in some cases, washed away. So there's a real existential threat people. So the idea behind the case is to allege violations by Australia of various rights under the ICCPR, specifically the right to life under Article 6, which is both the loss of life itself and also the qualitative issue of a life of dignity. There's also the breach of the right to home and family, or interference with home and family. And there's the interference with the rights of minorities to exercise their culture. So I think as far as relocation is concerned, what's really striking when you talk to these 8 clients, these 8 complainants, is they don't want to relocate. And that's striking about this particular case, is that the remedies that they're seeking from Australia, so through the recommendations of the Human Rights Committee, are remedies that would allow them to continue to live their lives on their home island. So they're asking for adaptation remedies, including things like funding for emergency seawalls and pumping and drainage and things of that sort, as well as mitigation remedies, which was about ceasing actions that contribute to climate change, so coal generation, setting some emissions targets, things of that sort. So that's sort of the case in a nutshell. What's different about this case compared to other cases, which I think we'll probably get onto in the discussion, is that it's not linked to any specific project, and so, for example, it's not about approval of a particular new coal mine or something of that sort. It's about the harm that has been caused and is continuing to be caused by climate change more broadly. But what that means from a domestic legal point of view is there's nothing specific to challenge. So what we're seeking here is, some recognition of the responsibility and the culpability for the human rights impacts of climate change. And part of taking that responsibility is to take the measures that are necessary for these islanders to be able to continue to live a dignified life on their islands and not be forced to relocate, and to take the measures that are necessary so that the situation doesn't deteriorate into the future.
Yeah. So in addition to declarations around the existence of the rights and the impacts of the actions of the government on those rights, what other remedies can the Commission sort of provide? What will you be sort of hoping as to be the outcome in its final form if you're successful?
Well, the committee has no compulsive or coercive power in terms of remedies. It can make recommendations, and so among the remedies that the authors are seeking to have recommended are, as I say, emergency funding for seawalls and those sorts of adaptive measures to to allow them to deal with the damage that is happening as we speak. But also they're looking for recommendations for changes in policy, and this, I mean, that leads into the perennial problem with climate change litigation, which is causation, and that's a theme that comes through really strongly in the government's response to the communication in this case, which is to say no one country is responsible for rising sea levels, and if no one country is responsible, how do you sue them? And then, as I say, that's the perennial problem in litigation in this area. But of course, it's not unknown to public international law that there are certain types of wrongful acts for which states can be jointly responsible, and in this case, the Australian government has the responsibility for the Torres Strait Islands and to take all the measures within its power to protect the lives and the cultural rights of the people in the Torres Strait Islands. So it's their responsibility, we say, to take measures, as I say, take measures to allow them to adapt to the harm that's being done, but also to prevent future harm by doing what they can within their climate change policies.
Yeah. No, look, I think it's interesting that here in Australia, recently the federal court in the first instance handed down its decision in the sharma case, a case again brought by young people. But in that case, Justice Bromberg recognised a novel duty of care being owed by the Minister for the Environment to that class of people being young people in Australia. I mean, one of the things that was quite striking in that case was that the minister didn't challenge the scientific evidence that was presented. But then, obviously the other sort of important component is the finding of the duty, and, appreciate that is on appeal. But can you perhaps tell us, do you see anything coming out of the establishment of a duty in the form sort of looked at in the sharma case that may have any bearing or relevance in terms of what the authors are seeking?
It's an interesting question. There are a few points of difference which mean that the helpfulness of the duty in sharma is limited for a situation like our clients. One is the one that I alluded to earlier, which was that sharma was about challenging, or not challenging exactly, but seeking an injunction to prevent the minister from approving a new coal mine, because that's an approval that's required under the Environment Protection and Biodiversity Conservation Act, so the duty of care was found in connection with that particular statute, because the statute contemplates intergenerational equity and harm to future generations as one of the things that needs to be taken into account. And Justice Bromberg found that was a relevant consideration in the admin law sense. So it has to be something that must be considered for a lawful decision. And then there, as you say, Llona, there were some very, very detailed factual findings which were not challenged by the Commonwealth, and I suspect they might regret that choice now. And they're set out in Justice Bromberg's judgment. Those might be helpful in the future, but then ultimately His Honour found that there was not a basis for an injunction because it wasn't established that approving the mine would necessarily breach the duty of care to future generations, and that was partly because it was said that there could be measures that could have been put in place to ameliorate the harm, so no injunction was granted to prevent the approval of that mine at that stage. So in our case, there are a couple of differences. One big difference is that there's no specific decision or specific project that's being challenged. So there's no approval, there's no administrative decision to connect to the harm. That's one problem. And it's also the case that since the finding in sharma was made, a number of new coal mines have been approved. I think at least 4 that I know of. And in each case, the minister has referred to the duty of care and said, I have considered this duty of care, and I conclude that there is no future harm that would come from this coal mine, and in any case, if we didn't build it, someone else would. So, there's no harm, and so the duty of care hasn't prevented the approvals from taking place. But nevertheless, it's an important step. It's a very important advance if it survives the appeal, to say that is something that needs to be taken into account in environmental decision making prospectively. And so it might also, in terms of informing the litigation choices of climate change activists going forward, it might be that they need to think more about connecting a particular decision to the challenge that's being made, as opposed to challenging for harm from climate change in general.
Great. Now, look, I think that highlights some of the, the real differences between the approaches that can be taken under domestic legal frameworks, where you have specific, decisions or duties, or under statute, and the nature of the cases that are brought under international law. Robin, perhaps if I can bring you back in on that question, because we've had a question from the audience with respect to, comparatively, how important are, the international versus the domestic advocacy approaches and litigation campaigns? Do you see sort of one forum or other having a more direct impact, or, just serving different purposes?
Yeah, so thanks so much for that question, because I think domestic courts are critically important. And one avenue that hasn't yet been fully explored in the United States, but needs to be, is about the discriminatory impact of the way that government agencies are making decisions about who gets the funding to respond to climate change impacts. And an analogy is, in the United States back in the 90s, a group, the American Baptist Church, sued the US government for the discriminatory application of asylum law, because 98% of Salvadorans and 97% of Guatemalans were denied asylum, and they won that case. And so I think we need to use those frameworks about how domestic laws are being, how US government agencies and national government agencies outside of the United States, how are their mandates impacting, as Alma said, Black, Indigenous, and people of color communities? Because in the United States, it's very clear that those communities are not getting equal access to the resource that federal government agencies have.
Yeah. So then another sort of question that's come through the Q&A, which I think, if perhaps I can bring Alma in on this one as well, links to, in terms of domestic litigation, particularly in the US, beyond refugee claims, what other sort of litigation strategies have been successful in terms of causes of action that have been brought?
Yeah, I think this is a great question, and I wish I had more to share on it, because I think it's a really good insight that local and domestic courts might be useful in this area. One thing we haven't talked about yet is climate gentrification. So the changeover in populations who can afford to live in a place after an environmental disaster. And so, for example, in New York law, there are very strong environmental conservation laws that require developers to consider the socioeconomic impacts of development. And so there are tools like that law that can be used in the aftermath of disaster to make sure that developers are considering equity issues when they're rebuilding, to make sure that communities who've been affected by disasters aren't then pushed out of those communities. So I think that's one example in the US. And then some of the work that we're doing in the EU is to explore domestic implementation of rights to life, rights to family life, protection against refoulement at the domestic level as well. So those are a couple of things outside of the asylum framework.
Okay, great. And Robin, do you have any views or anything you'd like to add on that point?
No, I think that it is so far under-researched in regard to what lawyers can do within countries to litigate issues not about, the climate change causes that are having impacts, because as Adam articulated, it's been pretty tough to get positive decisions from domestic courts. But I think this whole issue of the discriminatory application of laws within the United States and in other countries in this context of the climate crisis needs to be further researched to figure out what the litigation strategies are.
Yeah. Okay. Alma, you mentioned sort of the work in the EU, and one of the I think patterns we see in terms of displacement is coming from Africa into the EU. one of the questions that has come through is that some refugee status decision makers in Africa have reported that they're not yet seeing claims for protection based on climate change, even though they do know that it's driving displacement. Are you, through your connections with work and colleagues in the EU, seeing particular barriers around the ability to bring those types of claims in the context of climate change and its impacts in Africa?
I can't answer that EU Africa specifically, but I will say what I know from the US context, which is that often their screening interviews for asylum and immigration officers are acting very quickly. So if someone comes up and says, hey, I'm here in the US seeking asylum because of Hurricane Eta, for example, or a hurricane that hit my community, that immigration officer might say, okay, there's no climate or environmental grounds in asylum law. No credible fear, this case is thrown out. So part of the issue or part of the challenge or part of the opportunity is to train immigration officials to be able to recognize how climate is showing up and to be able to draw stories out of people that means that they would be eligible for legal relief. So for example, in that example that I just gave, that person might have been living in a climate vulnerable community because of a local ordinance that required members of an ethnic minority to live in a particular area, for example. And ethnic discrimination is a grounds for asylum. So this is just all a long way to say that there are ways to train our immigration officials, and I imagine this would be applicable in the EU as well, to make sure that we're not throwing out valid asylum claims just because they're leading with a climate story.
Okay, great. Thanks for that. We've got a couple more minutes and a couple more questions. One, and I might sort of put this to Solomon and perhaps Adam, is how are recent advancements in attribution science being used to support litigation cases, and in particular supporting those tests of causation and foreseeability? Solomon, would you like to jump in?
Yes, for the purpose of this question, I would have a little to contribute, as I have not personally done a lot of research or up-to-date findings on the attribution side. So kindly pass the opportunity to Adam.
Okay, great. Adam?
As far as foreseeability is concerned, it's being used quite a bit. There's a fair amount of scientific evidence that was put before Justice Bromberg in Sharma, and it was, as I say, it was basically uncontradicted. So for foreseeability purposes, it's there. Causation, I think, is still a hurdle. And the same is true in our case of Billy. There's a fair amount of the climate science that goes to the questions of foreseeability, but attribution and causation, I think, are still courts and decision makers are having difficulty accepting that causal link. So that's probably an advance that needs to be taken better advantage of, I think.
Look, thank you very much for that. Now, I'm conscious of time. I appreciate that there were a couple of other questions that came through that we haven't had a chance to get to, but I'm sure that there will be opportunities for the audience to reach out directly to the organisers with particular questions if they would like to follow up. I'd like to just thank our panellists once again, Robin, Arma, Solomon and Adam, for a really, really sort of insightful and important discussion this morning. Really appreciate your insights, really appreciate your time. And I'd like to say, thank you very much. And I hope everyone enjoys the rest of the Kaldor Centre's annual conference. And I encourage you to sort of log in and attend all the other sessions that are upcoming over the next day or so. Great. Thank you very much, everyone.